welcome back to Legalese Translator. My name is Heather Hurlitzman, and joining me here today is Dan Rosman. Hi, Dan.
Hi, Heather. How are you?
Great. And so today we're going to talk about pretrial conferences. So Dan, I know this is a step in the rules and civil procedure. So can you sort of like tell us a little bit about the basics of what is a pretrial conference?
So a pretrial conference is a step in litigation that comes after one party sets the matter down for trial. So when you, a lot of the previous steps that we're not going to talk about in today's video in a litigation are completed, the matter then is ready to go to trial. So once that happens, within 180 days, and that's the rules right now, within 180 days. And I want to preface that by saying we're filming this video in the time of COVID and an emergency, where a lot of these deadlines have been suspended or changed. So I want you to make sure you check the practice directions, and I want you to check the notices that the courts have put out to see what your timelines are. But in normal times, within 180 days of setting your action down for trial, you would attend a pretrial conference. So what that is the parties with their lawyers meet a judge, and they go over the case, they go over the issues, they try to settle. The judge tries to have create pathways for the parties to settle, and if that is impossible, the trial the organization of the trial is figured out. So what's the date the trial is going to be held? How long is it going to be? How many witnesses? How long for each witness? All that stuff will be sorted out at the pretrial conference as well.
0.06 is actually quite detailed about the kinds of things that the conference discusses. Do you want to just kind of like maybe give us a highlight of some of the things that are considered at the conference?
Right. So like you said, it's at rule 50.06 of the rules of civil procedure. And even before we say anything else, always check the rules before anything, even before watching videos about how to do pretrial conferences. Look at the rules, look at the practice directions for the region that you're in, because they're going to be a little bit different everywhere. Sorry, but the you're right. Rule 50.06 sets out some of the things that the judge is going to go over with the parties at a pretrial conference, and I'll just go through them really quickly. I'm not going to read all of them; you can read them yourself. Right. But the first one, and the most important one, is the possibility of a settlement of any or all of the issues in a proceeding. And I want you to remember that it says any or all. So if you have a case that's got a lot of different issues, maybe you can figure some of them out, if not all of them, at a pretrial conference. It goes on to simplification of the issues. So maybe you can agree on some procedure on how to deal with those issues or how they're going to be presented at trial. The possibility of obtaining admissions, that's number 3. That's very important, because if you can get the other side to agree that a certain document is authentic, then your trial can be shorter, because you don't have to go through the whole process of the trial of proving a document's authentic. All these procedural steps and different little parts of a trial can be discussed and hopefully made easier at a pretrial conference.
Well, I see that basically the purpose is to make the whole process, the whole proceeding more efficient. That also sounds like.
It's there to just sort out stuff before the trial starts, so that the trial can be more efficient, faster. Everyone sort of on the same page of what's going to be said, what's going to be done, and how it's going to be said and how it's going to be done. Again, that's after trying to settle it completely.
Right.
So the main goal, I think, at least on the court's perspective, is let's try to settle this. If we can't, let's try to figure out how we're going to move forward.